So I would like to begin actually with our first speaker. Let me read a little bio on him, you might say. And it's Dan Itse. And it's not Itse, by the way, although he doesn't take umbrage at that, but I've known him so long, I take umbrage at it. So if I correct you and you call him Itse and I say, no, it's Representative Daniel C. Itse, he certainly earned that. But he's a scholar of both the national Constitution and the New Hampshire State Constitution. He's also a board member of this organization, the National Heritage Center for Constitutional Studies. He's chief engineer at White Cliffs Technology, although he doesn't spend a whole lot of time at that because he's so busy up at the State House. He's CEO of Christofferson Engineering and a sitting member, although I don't see him sitting very often, just in time to take the votes, of the New Hampshire General Court, which of course you know is the House of Representatives, where he's chairman of the House Committee on Constitutional Review and Statutory Recodification. How did you do that? How did you get in to be chairman of the House Committee on Constitutional Review? Thank you, Lord. He's a good person for that job. And so we'd like to bring him up, give him your attention and your greeting, and he will be sharing with you particularly about the Article 73A, which was presented to voters as allowing the judiciary to better manage the judicial branch. Presented as such, it was subsequently ratified by New Hampshire voters, amending the New Hampshire Constitution in November of 1978. And of course, now, as we have CACR 26, which I suppose just conveniently we could say is to rein in an overactive judiciary. Anybody vote for that? Yes. I hope all would. It's become necessary. So, Representative Itse.
Thank you. What I really wanted, I'm kind of here at the cheerleading section tonight. The other representatives who are coming after me are going to give you a lot more detail and particulars about the battle or the conflict that is in front of us. What I want to do is motivate you as to why this is your job in particular. Now, CACR 26 was mentioned as being before the legislature. Right now, it has passed the House. We needed 239 votes, and we got 239 votes. It's now in the Senate. And whether or not it escapes the Senate is in large part up to the people of New Hampshire and how much they can convince the Senate to put it forward. Now, the reason this is important to you is to understand who you are relative to our government. I've studied the New Hampshire Constitution, has been mentioned. I've also looked at the other constitutions of the other states. New Hampshire had sat in the unique position of having the first constitution of any government on this continent that limited the government. And then, after the war was done, we actually had the last constitution as well. And we looked at all the other constitutions that were ratified during 76 and the Massachusetts Constitution in 79. And we looked them over and we took the best of the best of the best. You often hear about our vaunted right to revolution, which actually is not a right to revolution, it's an obligation. It states that government be instituted for the common benefit, security, and protection of the whole community, and not for the emolument of any one man, family, or class of men. Therefore, whenever the ends of government are perverted and the public liberty manifestly endangered, the people may, and of a right ought, and ought is the moral imperative, to reform the old or establish a new government. The doctrine of non-resistance against arbitrary oppression is absurd, slavish, and destructive of the good of mankind. The word ought and that last sentence appear in only one other constitution. It's not Massachusetts. This isn't the knockoff of Massachusetts. It's the Maryland Constitution. So they went through the various constitutions. They took the best of the best of the best. And being an engineer, I've done a spreadsheet to look for key liberty words in all the constitutions. things like where the power of government originates, power of the right of redress. And when you stack them all up, I came up with about 15 or 16 words. Only New Hampshire has them all. All the others are deficient in at least 1 or 2 and sometimes 7 or 8 of these distinctions. So we have the best statement of American liberty, bar none. Now, where does that put you in relation to your government? And what has the government forgotten? I like to refer to us as, you remember the Muppets, pigs in space? Goobers in government. The important thing to remember is that those of us up in Concord, we aren't the government. You're the government. Government has no power that didn't first come from you, the people. Part 1, Article 38, which is originally the last article, talks about that the administration of government, those of us up in Concord, the representatives, the people in the executive department, the judges, we are the administrators of government. We are there on your behalf. And it's important that you know that this isn't just rhetoric. This is real. How do you know it? Your Constitution tells you so. Part 1, Article 38 says that all power originating in and being derived from the people. All the officers and representatives of government are their agents and substitutes, and at all times, not just 91A, but at all times accountable to them. That means that you're supposed to be looking over our shoulders, making sure that we're exercising your power the way you want us to. If you then go another key phrase or key how do I put this? We've been bamboozled. The judicial department, the legal profession, has somehow convinced us that they are the arbiters of the Constitution. And it's very important to understand that I'll go to this point first. The Constitution tells you how to read it. It isn't just this mystical document that somehow you find things in. Part 1, Article 37 is called the separation of powers. It doesn't actually have a title. But it says the 3 powers of government, to wit, the executive, the legislative, executive, and judicial, they're in that order for a reason, ought to be kept as separate and independent of each other as the nature of free government will admit. That means that there must be some restraints, one department upon another, or as is consistent with that chain of connection that binds the whole fabric of the Constitution in one indissoluble fabric of unity and amity. That means that you can't read one article separate from all the other articles that might touch upon it. That means that you have to read the whole thing and understand the whole thing. So when the judges say, well, the three powers of government need to be kept as completely separate from each other, and they don't read that last one, as is consistent with that whole chain of connection that exists in the whole document, well, that means if you want to understand how one branch has power over another branch, you have to read the whole document and see how the 3 branches relate to each other. They don't like to do that. They like to just hang their hat on that one little phrase. They forget that we have the power to give the executive the power to remove them by bill of address. They forget that we have the power to remove them by impeachment. They forget that we create the lower courts. With the power to create comes the power to deconstruct. Matter of fact, we had that power over all the courts until 1968. But you, the people, took that power away. We had the power to make the rules for the courts until 1978. But the judiciary convinced the people that it would be a good idea that if they made all the rules for administering the courts because they were different from county to county, and you know, the Superior Court had the rules that they wrote for themselves, and the legislature might amend, and the district courts had the rules they might write for themselves, and the legislature might amend. And so they said, we should really wrap this all up into one function of the Supreme Court. That was the reason that you gave them that power. But you need to be constantly vigilant. Article 38, which I alluded to before, makes not the judiciary the arbiters of the Constitution, it makes you the arbiters of the Constitution. It says that a frequent recurrence, recurrent means to read, study, and discuss. Frequent recurrence of the fundamental principles of the Constitution, and justice, moderation, temperance, and constant observance, or adherence to justice, moderation, temperance, industry, and frugality, and all the social virtues are indispensably necessary to the preservation of liberty. The people ought therefore to have a particular regard to those principles in the selection of their officers and representatives, and they, the people, have a right to require of their lawgivers, that's people like myself, the other representatives here tonight, and magistrates, that includes the people in the executive and the judges, an exact and constant conformance to those principles in the formation and execution of the laws necessary for the good administration of government. Remember, we're not the government, we're the administrators. We're the worker bees on your behalf because it's your power that we're exercising. So, if you see a body of government misusing some of your power in a way that you don't approve of, what do? You amend the Constitution because it's your document, it's your contract that creates the government. It's your job to amend or to change or to reform, replace that government whenever you see the public liberty manifestly endangered, whenever you see the ends of government perverted. How much time do I have left?
You have 11 minutes.
Oh, good. Okay. Now, we're looking at the courts, and a funny thing happened on the way to the courts the way they exist now. We see people come out of our courts, and Representative Ingbretson is going to tell you about this, and they have the perception that they are not receiving justice. They say, we're not receiving justice. Well, the Constitution, Part 1, Article 35 says we have judges that ought to be as independent as possible, and that's why we give them lifetime appointments. So they'll be independent, and they'll be able to provide the people with justice. And Article 38 says that we need to constantly adhere to justice, moderation, temperance, industry, and frugality. What does that word justice mean? Well, I suspect that every one of you can reasonably articulate what justice means to you. It's pretty straightforward. If you go back to a 1781 definition, which is what would have been common at the time it was put into the Constitution, it meant that virtue by which we give every man his due, first definition. Second, vindicative retribution or punishment. That pretty well sums it up. I think everybody would agree with those definitions of justice. Well, by 1828, a new term had infiltrated into our definition of justice. It's called distributive justice. I looked at that, and I thought, that's a word, it just makes me feel uncomfortable. What does distributive justice mean? Google distributive justice. I found a paper that talked about another paper that said, well, it's thought not to have been seen before the 1700s, but actually it goes back to 1200. It comes out of the church. Loosely interpreted, it meant that a poor man who was starving had the right to steal. Forgot about that thou shalt not steal thing, you know. They justified it, and they said, well, that property rights are a human conception. And when a man is starving, he reverts to the law of the jungle. So this became the rule of the church. And in fact, during the Middle Ages, if you were poor and starving, you could go to your local priest, and you could say, I'm poor and I'm starving. He'd say to the rich man over there, give him money or I'm going to have you excommunicated or thrown in jail. By the French Revolution, this had become the concept that every member of the community has a right to a subsistence level of the property of that community. In which case, you'd start arguing what's subsistence. This is distributive justice. It infiltrated into our system, and I have a Black's Law Dictionary, 1991 Centennial Edition. The definition of justice: 1, judge; 2nd, the law; 3rd, commutative justice, which means contract that law. That's that virtue by which we give every man his due. Distributive justice: what the state owes the individual or the community owes the individual. Social justice: what the individual owes the state. I'm done. Do you notice what's not on the list? Punishment. So when people go into a court and the court rules say that the judge in the courtroom may waive any rule in the interest of justice, and his justice is radically different from your definition of justice, what do you think happens? But whose power is he wielding when he's in that courtroom? He has plenary authority in that courtroom. He can make rulings and they must be carried out. But whose power is he using? It's your power. If he's using that power inappropriately, if you believe that the rules of the judicial system aren't doing what you intended, then it is your right, your obligation to reform or replace the government. We do that, well, first we can do that at the ballot box, and hopefully we elect a legislature that has the courage to stand up to the judiciary. And if we can't do that, we amend the Constitution so that hopefully all 3 branches of government, but in this case in particular the judiciary, understands what we meant when we put the rules in that they have to follow. This is how you reform or replace the government. It is your obligation, but to do that, you have to know what's there in the first place. You have to know when the members of government, or the administrators of government, that's a better term, are not carrying out the power that you delegated to them. This is probably the most important concept. If you can walk away with anything tonight, is that the power in government does not belong to the legislators, it does not belong to the governor, it does not belong to the judges, it belongs to you. You've given it to the government by power of attorney. It's been signed over them to execute on your behalf. If you've ever had a power of attorney or know somebody who does, if they find that power of attorney being maladministrated, it's withdrawn. If necessary, given to another, or just withheld. We've got an important job here. We've got an opportunity. We do have CACR 26, which has passed the House, but now we have to have a populace that really understands the magnitude of the problem so that they can carry it forward and convince the members of government to put it on the ballot so they can vote on it. And this isn't an easy thing, because what you're doing is you're asking the members of government to turn back power. I want you, here's another twist on this. If the court isn't going to be making the rules, or is not going to have the exclusive power of making the rules, then that means the legislature can make the rules. Who does the legislature represent? It represents you directly. That's correct. This is very important, because now you're going to have the opportunity when you see things going awry in one court or another, to bring it back to the legislature and say, this went wrong over here, we need you to fix it. You're going to have the opportunity to control your destiny to a greater degree, but there's a tough thing about liberty. It takes work. I don't know that I have anything, I'm leaving time on the table, aren't I? That's odd for a politician. 2 minutes. I think I am going to turn it over because I know that the gentlemen coming after me have a lot of detail to give to you. And it would be to your benefit to be able to hear everything they have to tell you. Thank you.
GrokTV.